Hello, and welcome to Stowe Talks, a podcast designed to support people going through a relationship breakdown and all the challenges this brings. I'm Matthew Taylor.
And I'm Lisa Gatchell, family lawyers at Stowe Family Law. And today we're delighted to welcome specialist divorce financial planner Ceri Griffiths of Willowbrook Lifestyle Planning back to the podcast to look at the realities of a high net worth divorce. It's really great to talk to you again, Ceri. Can you start by just introducing yourself to everybody?
So I run a company that's called Willowbrook Lifestyle Financial Planning, and I give advice exclusively to women who are divorcing CEOs and millionaires. So absolutely hyper niche. And it didn't start there. It's evolved to that place, essentially working with women where there's a power imbalance and where there's complex financial situations in which the support that I give and the specialisms I have around financial abuse and narcissism and holding the resolution specialist accreditation, all of those things are really adding value to the client.
Great. Well, as Lisa said, it's a welcome back, friend of the podcast. Ceri joined us back in series 2 to talk about pensions, which was anyone who's listened to these know it's like my area of expertise. Today is a lot less geeky and a little more glam because we're talking about high net worth divorces and the things that are peculiar to them. So shall we start, what is a high net worth divorce, Ceri? What's the classification start at?
So there's no specific classification that I'm aware of within the legal world. In FCA, so the Financial Conduct Authority, the classification for a high net worth mortgage client would be $300,000 a year income or $3 million in assets. So that gives some kind of reflection, although I find that it's a higher level that my clients have on the asset schedule. So the total assets tend to be quite a bit higher than that. But that's a good kind of basis, I think. Is there a specific legal one? I've never come across one, Matt.
No, I've used the FCA one before. I think it's a bit, if you know it when you see it,
Yes.
It's one of those, and there's not hard and fast rules as such. But when we're talking about high net worth, if it's from an asset basis, and you can have very high incomes and actually very low assets sometimes, but from an asset basis, I think what we'd always do is kind of strip out the family home, strip out the pensions, and then it's about investable assets. And I think 3 million is a pretty good level to start talking about high net worth. I mean, I don't think it really matters to give it a label necessarily, but that's the sort of territory that I think we're probably getting into.
I think what matters is the complexity of what we're dealing with, because what happens in a high net worth divorce or even a marriage is that the assets grow to a level that they are invested maybe in more complex areas, and the actual discussions around how you strip that back get more complex from a legal perspective, but also a financial one. And that's where the expertise, I think, is particularly key.
Yeah. Especially when we start talking about things like taxes and sort of like, definitely need to speak to a financial planner.
Yeah. So in terms of, before we get onto maybe the nitty gritty of the finances, I think in your intro, what I found particularly interesting is talking about the power imbalance. I mean, maybe you could expand on that a little bit, because I think that's a common feature that Lisa and I would probably both recognise in this area.
Yeah, I think when you are in a affluent marriage, it is common that one party has been the one who has been very career focused, and therefore the other party has typically, there's been a compromise made and normally a family decision made about there are some sacrifices that need to be made for this person to continue their career at this level. I work specifically with women who are divorcing CEOs or senior executives, also those who are divorcing private equity managers, hedge fund managers. And there's a commonality in that typically involves some travel abroad as you're moving through roles to get into those senior positions, which produces the difficulty of you continuing a career if you aren't the person whose job has moved abroad. And then the resettling and the rehoming and the impact on the family. It is quite common that one person, and it's not necessarily the wife, I specifically work with women, but one person will make the decision, actually, we would function better as a family if you were focused on the work and I was focused on the family. So that is often the case. And with that, then a power dynamic can develop where one person becomes really in control of what the finances look like, dealing with the money, bringing the money in, and the other person less exposure to. And again, that is really common in lots of families where this power dynamic doesn't exist. It can be a normal family setup that one of you is just more comfortable with the money than the other. Where that dynamic becomes more tricky and where we need to be more conscious of it is where there is a lack of line of sight from one of the parties, and therefore their understanding and their knowledge has stopped at some point, and there's some catching up to do. There's a really interesting study that was done, and the publish of it was in May this year by some German researchers. And I want to point this out as well at this point, because there's another dynamic that plays out here, and it isn't one that I'm imagining. As you can imagine, clients who approach me are divorcing CEOs. That's why they've reached out to me, and they're noticing this power imbalance because of the social media content that I have. I talk about that specifically, therefore they're attracted. So I see a lot of it. But there is research that backs this up, and I'll share this, and you can put a link in the description here, and by some German researchers that showed that 18% of CEOs displayed moderate to high levels of narcissistic personality traits, compared to just 5% of the normal UK population. So that's a really interesting, it wasn't UK population, it was a German population actually, but just compared to the normal population. That's a really interesting dynamic that also plays out often within these types of divorces. And certainly a large proportion of my clients, while we don't ever label the ex as a narcissist, we are very conscious that those traits might be playing out. And certainly a lot of my clients are starting to explore whether or not that has been a part of their marriage.
And insofar as narcissism goes, obviously that's a bit of a hot topic and that we dealt with in the podcast a lot. And, we have another return visit from another friend of the pod, Ceri McKenna, who's going to be talking a bit more about narcissism in the next couple of weeks with us. So stay tuned to the feed for that. And that's obviously her previous episodes. Lisa, what do you think about that? Is that something you recognise from your high net worth cases where you've got, I guess Ceri's coming at it from a very female perspective, given her client base, maybe narcissistic or at least very, very difficult personalities on the other side often?
Yeah, I think you have to have some particular personality traits to be able to get to those high positions and manage those, manage the risk that they often do within their working lives to be able to get the gains that they then achieve through their businesses or their employment. There is definitely a feeling of they know what's going on and therefore you should automatically. So, and that goes through to their spouse as well. And so when we're talking about things like disclosure and asking for information, it can sometimes be a lot of, well, why? Why do you need that? I've told you this is what the balance is. Why do they need to see that? I've told them that this is what it is. And a lack of understanding as to everybody needs to be on the same page as far as all of that information is concerned. That often quite used to getting their own way because they're quite high up in companies. People tend to do what they say, if you like. So I think there are definite traits. I can absolutely see that.
I think something else is that the greater the value of the assets that has been generated by one party's efforts from a financial perspective, the less likely they are to recognise what we call the sharing principle. The fact that the starting point is a sharing of matrimonial assets, because there's often, not always, but by no means always, and I've dealt with plenty of clients where it's been accepted, it's a marital partnership and we start at 50-50. But there are certain personalities who say, well, hang on, I've been out at work doing all this. How can that possibly be right that she has been at home and then she gets 50-50 of everything? To which the answer is quite obviously, Ceri, what you said is, well, think about the sacrifices that have been made to generate that. And I think there are very few relationships like that, marriages like that, where the financially weaker party hasn't had to pick up the slack of keeping the house, doing the life admin, looking after the children and raising the children, whatever it may be. So that can be a really common thing. You've got two key principles. The bulk of cases are needs cases, but these can be sharing cases. So should we do a little I'm going to throw it to you, Lisa, you can do this, a little legal bit on needs versus sharing, and then Ceri, you can maybe feed into how the sort of financial instruments play into that.
Yeah, absolutely. For most cases, we're looking at needs principles. So we're looking at what are the assets? Can we meet both parties' needs? And so what do I mean when we talk about needs? I mean, predominantly there are three needs. So there are housing needs. Do we have enough capital here to be able to rehouse both parties? How are we going to do that practically? And when we're looking at needs, it may be that actually sharing those assets equally doesn't meet needs, because one party's got a higher income and therefore they've got a higher mortgage raising capacity, whereas the other party may need more of the capital because their mortgage raising capacity is lower. And actually they might end up with equal housing at the end, but there's an unequal distribution of the assets to be able to achieve that. So, we're looking at meeting those housing needs rather than just splitting the assets equally. We then look at income needs. So income needs are, how much do you need to be able to live comfortably each month, ideally to the standard of living that you enjoyed during the marriage? And is there enough money there once both parties have sort of maximised their earning capacities to be able to do that? So that's when we look at things like periodical payments, spousal payments, etc. And then we have pension, so future retirement income needs. So what are the pensions? What incomes are they going to produce on retirement? How do we share those between the parties to produce a fair outcome? So for like, I would say 90% of the cases that we deal with, actually there's only just enough assets there to be able to meet all three needs. And sometimes we can't meet all three needs, and therefore we have to make really difficult decisions as to which ones we're going to prioritise and how that's going to work. And it comes down often to practical considerations as to how we're going to it's often about thinking outside the box, genuinely, how are we going to, these are the assets we've got, how are we going to make these work to meet the needs of the parties moving forward? When we start to move on to high net worth cases and parties who have got assets and income that meets their needs, needs can be easily met. So we have a surplus of assets. We then start looking at the sharing principle. And that's when we consider the fact that the starting point is that marriage is a partnership and it is a contract. And when you sign up to that contract, you are signing up to the sharing principle, which is perhaps not something that people, I think we've spoken about it before, I don't think people often realise the importance of that from a legal perspective when you're signing the marriage certificate on your wedding day. And so the starting point is that assets should be split equally between the parties. So the sharing principle states that, the assets should be split equally. And then we have various considerations that we can take into account when we're looking at things like short marriages, or if there's been a particular external contribution from one party into the assets. Perhaps they don't have children. Perhaps they've had completely separate incomes during the, they're both earners that have completely separate incomes during the course of their marriage, or perhaps they've just kept their finances completely separate. So there are, the needs and the sharing principle are very different. But certainly when we start to get into the high net worth cases like we're talking about here, we move much more into sharing, because there should be assets. The assets should, and when I say needs, I mean, the needs of a high net worth individual are not going to be the same as the needs of Joe Bloggs down the street. Their needs are understandably going to be higher because that's the lifestyle that they have been living. But there will be assets usually over and above those needs that we can then look to share out.
And I guess this comes back to, Ceri, what you were saying about the kind of the slightly more exotic way in which those assets can present themselves. So do you want to give us a bit of a run through of some of the complex structures that are quite often involved in your clients' cases?
Absolutely. Before I do that, can I just reflect on something that Lisa said and just bring in a little bit about one of the things that I think is super important at this point, and I hope those listening take away, is that it is really common where there is this power dynamic for one party to present a spreadsheet of all the assets and say, this is what we've got. Let's just keep it amicable. Let's just kind of agree a 50-50. Let's not have a big nasty legal battle over this. And the understanding of the needs and the sharing principle, getting some legal advice, understanding what your picture could look like is absolutely vital. So an encouragement to do your due diligence and to have the awareness that doing your due diligence doesn't mean that you're not being amicable. And that is a really difficult balance, I think, sometimes. If you go and do that due diligence, there can be the comeback that you were the one who's made it legal, you're the one who got lawyers involved. You can do it secretly. You can just go and get some private legal advice. And you probably will take it a little bit further if you've got these complex situations. But I'm just really conscious that we need to make sure that in these scenarios, you're aware of how your situation might play out, because typically that spreadsheet is more complex than what it first looks like. And that actually leads really well into your question, Matt, then. So when you are divorcing somebody who is a high earner, the chances are how they are paid is quite different to the norm. So if we start with those who are employed in executive type roles like CEOs, chief financial officers, COOs, in that executive suite, the chances are they have a long-term incentive plan, or an LTIP. It's a way of rewarding senior staff so that they are loyal. And it is typically that they would receive cash or shares, and they can receive them in reflection of work done or work to come. There's a nuance there depending on their particular scheme. And the idea is that they won't get paid on that for a period until the future, 3 or 5 years, called the vesting period. Vesting is a word that will come up quite a lot with long-term incentive plans. And so you might have a partner who is being paid a salary and not actually have a line of sight of what those future vesting shares would look like. And they are typically a large proportion of what their total income could be. A lot of the work that I do is around explaining how a client's specific long-term incentive plan works, looking at the terms and conditions, talking with it with their legal team, and then actually working out what that looks like post-tax as well, and getting a line of sight on what benefits that could look like. And then there's a legal aspect to this, in so much as some of that work will be after separation, and some of the work for this reward could be before separation. And it is very particular to the scheme that they are in. And so we look at the scheme rules, and then your legal team would have a conversation, and that would be how you would make some decisions about what would seem an appropriate amount of that. So if we have somebody who has a long-term incentive plan, what you typically get is a set of rules, and then you'll also get their almost like their balance of it, and it's a statement that will show these are all their vesting plans, this is when they're going to vest, this is how much they're going to get. It's about working out whether or not any of them, or all of them, or some of them are things that we would class as marital assets.
Yeah, and they can be quite complicated because of these sort of vesting periods, because they will be tied to performance. So you might, going back to the spreadsheet that's presented at first blush, which often comes with the phrase of, you don't need to see a lawyer. No, don't waste your money on a lawyer, because everyone hates lawyers, understandably. But also, that is a bit of a red flag to us lawyers. And that can be, this is what this is going to pay, and there we go. And then on a bit of due diligence, you might look into it and go, well, actually, there is a sliding scale, because if the share price is between X and Y at this period, then they might get 50% of the total possible value. If it goes up another stage, you might get 75%. So you end up with this matrix of potential possible outcomes. And then you have to factor in the taxes to come off that. And often the tax can be in different jurisdictions. If, you talked about international travel before, Ceri. So what jurisdiction are they receiving remuneration in? And often multiple jurisdictions. So it's not necessarily straightforward, and it's very... unless monies have already been received, obviously, or are very shortly about to be received. If you have it's common to have a 5-year term on an LTIP. If you are looking 3, 4, 5 years in the future, your degree of certainty is going to change over that period of time. And then there are arguments about whether that work to be done is something that's shareable or to meet needs. So how do you, when you're looking at these, Ceri, how do you go about assigning value to these slightly hazy, less certain assets?
So I'm never the one who assigns the value. In fact, we would typically get an expert involved if we were going to get a specific value, particularly if we move on to more of the private equity side of things. When we are looking through, we would have a look at what the scheme rules actually lay out and get some idea about what those hurdles are that need to be met. They are normally significant values. We're talking equal to their salary, and then 2-3 times their salary on top of that is a typical amount that you would get in one of these schemes. And that's happening every 3 to 5 years. So it is vital that we get to a place that we have an agreed amount for them. In my experience, there tends to be a cut-off point by which any compromise or negotiation can't be met. So if we are doing things and it's not going through court proceedings and they're in mediation, there is normally a line at which the partner who is actually receiving these LTIPs is just absolutely unwilling to cross. And the importance of what I do is about monetizing and actually showing what the difference is with or without the extra vesting shares in there as well, the ones that might come at 4 or 5 years. And then the importance in what you both do is actually in terms of what do your legal team feel is most likely to represent work that is done during the marriage, because that's one of the key things. It's whether or not the value for those shares is actually through future work that's done post separation, even post marriage. If we can't get to a place where we can value them, and this happens more with private equity, I find. So shall I just talk a bit about private equity, and then maybe we can come back to that sort of thing. So in terms of private equity, so this would be hedge funds or private equity managers. They have a really similar remuneration, but they're not employees typically, and they are remunerated with a salary sometimes or with drawings. And that is normally a really small proportion of their overall income, but that's the only part that they pay income tax on. If they are also within a fund, actually investing in that fund, and they put the money forward for that, they will then also have a share of carried interest. But one of the other things that happens within these funds is that even if they don't invest within it, they get a carried interest in future funds. So I'm going to tell you a little bit about what carried interest is and how that plays out. But essentially, carried interest is the way that private equity managers earn most of their income. But it's not charged as income tax, it's charged as capital gains tax. And so we need to be sure that we are getting the right disclosure, because we're never going to see it on income tax returns. It's on the capital gains tax returns that we actually see it. And it works really similar to an LTIP. It is for the fund performing and reaching certain hurdles, they will get a certain return back in the millions typically. And that again is a really difficult thing to be able to value and to be able to know definitively at an early stage how much it could be. The same with an LTIP, whether or not the value is done during the marriage or post separation is one for debate. And what you find is the same with an LTIP. You have different vesting periods. They'll normally have a number of different funds, different times that these funds are going to vest, and different times that they'll have their carried interest paid out to them and then pay capital gains tax on it. So they are exceptionally difficult to value. And, you know, they can have experts come in and value these things, but it's so difficult to know whether or not you're getting an accurate value. And therefore, some decisions have to be made about whether or not it is worth even instructing a valuer or whether you take a completely different approach at all. Do you want to pick up on that, Matt? Because that, I think, probably pulls through to the legal side.
Yeah, because this is us now jumping the fence between financial advice and legal advice.
Yeah.
And what the court has to do, what we have to do as family lawyers, is there is a statutory steer to a clean break. So to try and get the parties separated financially as quickly as possible, the best way to do that is say, well, here are some shares that the husband has in the company, and we have to value it at X, but rather than transfer those shares half and half, the wife will take more of the other assets. So they end up with 50-50 overall, but you are dividing up who gets the assets. That works where you've got good solid values and you've got a high level of confidence in those values. In the situations that Ceri's talking about, and you've got a low degree of confidence, it can lead to unfair outcomes to do that. But sometimes you have no option. So there's something called Wells sharing, case of Mr. and Mrs. Wells from 2002. And in that case, the judge at the first instance, the first decision said, well, the wife will have a lot more of the non-business assets because the husband's going to keep the business assets. But this was a declining business that was losing money hand over fist. So the husband appealed on the basis that the court couldn't be confident in that value and was successful. And the appeal judge said that sharing has to be achieved by a fair division of both the copper bottomed assets, so the house, the cash, the stuff that's not going to change hugely in value, and the illiquid and risk laden assets, so company performance, which can go wildly up and down. So they actually didn't do wealth sharing in Wales, but that's become known as wealth sharing, is when you then say, okay, well, both parties have to have some of the risky assets and some of the non-risky assets, or instead of transferring the shares, because often you can't, often there are shareholders agreements that prevent that, you deal with, if you know that shares are going to be liquidated at a point in the future, the wife will have X% of those shares at that time. So that's another way of dealing with things. It doesn't always work. And quite often, in my experience, actually, the husband will be more keen to retain those risky assets, will simultaneously argue, these are incredibly risky, I need to have more of them. But also, I'd quite like to keep all the risky assets, please, because, he actually thinks I'll do better than they will. There's a bit of a salutary lesson in a case called Myerson from 2009, where the husband agreed to take these risky shares, so AIM-listed shares, and then the 2008 crash happened, and they lost about 90% of the value, and the court said, well, tough, because they might bounce back, and also you chose to take them. So, he might have benefited from some wealth sharing them, but didn't go down the route. So those are some extra complexities that don't apply, I think, to the sort of the quote-unquote normal cases where your value of a house is going to be probably okay, plus or minus 10%. There's always, some uncertainty, but that can really play into it. So I guess if you've got all this uncertainty level, coming back to Ceri, speaking to your client who might not be financially savvy, might not understand, how the assets are calculated, what they are, but really wants to know, what's my life going to look like after this? How do you factor that in, and how do you demonstrate to a client, okay, if you end up with 40% of the assets, 45%, 50%, whatever percentage of the assets, what does that mean for them in everyday life? How do you go about that process?
I think that is actually a really important perspective to have alongside establishing disclosure and working out what's on the table. There's a key path to travel down in working out how much money do you need for the rest of your life, how much is enough. And that involves typically understanding what you want that part of your life to look like, which is really hard when you're divorcing. You're in a really traumatic place, and actually thinking about what life looks like post-divorce takes a lot of effort and a lot of work. So working with a divorce coach can be super, super helpful. I've got a number of clients where I've worked jointly with a lawyer and a divorce coach, and actually the work that the divorce coach has done around helping us picture what that post-divorce life has been so, so valuable. I do a large element of that myself, but then if we can build on it in a coaching environment, it's really valuable. So understanding home, family, career, lifestyle, where they are now, how they got there, where they want to be is a big basis of what the work is that a financial planner will do. And then as financial planners, we'll help clients really accurately understand the cost of those, really think about what life is going to cost when the children leave home, when they're in early retirement, when they're in late retirement, because those are really different to necessarily the schedule that you guys are working to during the divorce. Life evolves post-divorce and costs, etc., change. And we'll get an idea of how much in total their future life will cost, and it's the life that they want to live as well. And then from there, using some software called cashflow forecasting, we're able to work out how much is a monthly income or how much is a lump sum, a one-off lump sum, would fill the gap between what they're likely to earn, what their existing pensions, etc., are, and what the gap is. And that helps us have some perspective and some context for the figures being discussed. They are big figures, and this is particularly useful work when their assets are available. There's very little point me sitting with your average person and saying, okay, what figure fills all of this gap is 2.7 million, because if that 2.7 million just doesn't exist at all, there's no use or value to them in knowing that figure. Where it is useful and valuable is if that 2.7 million figure is in the context of actually there's 12 million on the table. Okay, I can breathe. I can actually look at this and understand that my choices now come more from what do I think is fair, what's going to work for our family. It's not just monetary choices that I'm making. It's choices about the way that I want this divorce to play out, and what I'm willing to do. So it gives a lot of context and it gives a lot of expertise for them to actually be able to make informed decisions about what they truly want.
And I think just to give a little bit of a peek behind the curtain, so Ceri and I worked together on a case which finished in summer of 2023, along with Dr. Sue, the divorce doctor, another friend of the pod, and the three of us worked together with our client, who's the wife, who, you know, there were a lot of common features to things that we've talked about. Quite difficult husband. It was quite long. It went to a final hearing, which is a rarity. But I know that a client there got a huge amount of reassurance from speaking to Dr. Sue about the emotional side, who's far better at that than I am, and then speaking to you about the financial side, and rather than me going, I don't know, or trying to pick a percentage, and being able to say, okay, well, if I get this, then I'm okay. And that makes a big difference. I think that's really, Lisa, I'm sure you'd agree, that's hugely reassuring for a client to see what life actually looks like, rather than us bandying about case law and legal principles, which are kind of interesting for us, but pretty dull for most other people.
I think it really is, because I think people often come in with this idea of it's going to be 50-50 or it's going to be 60-40, or I've been told I can get 70-30 or whatever it is. And you know what? I don't know, like that percentage might be right, but it might not be right. And those, you know, throwing about arbitrary percentages really, in my view, just doesn't help, because it doesn't paint a picture. It doesn't show you what you're going to have, you know, where are you going to live? What's your income going to be? And I think that's where people really need to do the work, and doing things like the cash flow forecasting really starts to give those percentages a reality, because actually we can do that, and we can say 50-50 is brilliant. You know, that's going to absolutely meet all of these needs. You are going to be fine. Or actually you do need a bit more. So we need to be arguing for 45-55, because that's what's going to get you to where you need to be. And I think that's far more important than when we do get fixated on percentages.
I think there's a specific nuance that comes up in a high net worth divorce that makes it even trickier, which is that talking about millions is tricky with your friends, because there's this assumption of, well, of course you're going to be fine. You know, of course you're going to be fine. And actually, by the time you've bought a property and there's private school fees and you have paid off certain different things, it's not necessarily the case that you are going to be fine. And having somebody to work through those figures and talk about your very real fears is really important, because you might be feeling that those around you are just thinking, well, what is she moaning about? We don't talk a lot about money anyway in general, and particularly in high net worth situations, it is not common for you to sit around a table with your friends and talk about how many X million is where and what you're doing with it. So it breaks that silence down. The other big thing that comes up is this sense of needing to get security, but being scared to ask for it in case you get branded a gold digger. So this real worry that actually it's not that I'm after the money, but I really am worried, and what is the security? And getting that balance right, and finding a safe place that you can actually ask those questions and know that you're not being judged.
Yeah, and also having that knowledge of what life is going to look like for you. You don't get, I completely agree, Lisa. I hate talking percentages for all that. I've mentioned several percentages already on this episode. I don't really like doing it with clients because it doesn't help. And that's a really easy way to end up litigating on principle, which is a terrible thing to do. Your principle is it has to be 50-50. Well, I mean, it actually doesn't, other than the fact that you want it to be 50-50. But the other thing it can empower clients to do is to say, you know, if we give them their range of potential outcomes, and I wouldn't do it on a percentage basis with the client, but for these purposes, if your range of potential outcomes is, okay, you're probably going to get between 45 and 50% here, because there's an argument that some of it's a little bit non-matrimonial, then if you do the cash flow forecasting on that range, client might actually see, do you know what? I'd be fine with 42%.
Yeah.
You know, that would allow me to live the life I want to live. And it's the opposite of the gold digger approach, because then they say, okay, that'll do. And I'm quite happy to take a bit less to get it done quickly, to get it to minimize the legal fees. And if I walk away for a bit less than, you know, really I could get if we went through it further and spent another X on legal fees. And that's a really sensible thing to do. If you don't have that data, you can't know when to cut and run, can you?
Absolutely. And it isn't just about to cut the legal fees. It's the emotional toll that takes. And a lot of people that I've worked with have chosen to prioritize the relationships within the family, and knowing actually the figures that are broadly the ones that the other person is wanting work for me empowers them to say, okay, that works for me. Yes, technically maybe I can have more, but I don't need it, I don't want it, and this is what I want to prioritize. I want to prioritize being able to be in a room with that person, being able to, co-parent with that person. That's actually important to me. And the only way they can do that is with context.
Mm-hmm. Yeah, it's coming from an informed position, isn't it?
Yes, absolutely.
And especially when you're dealing with difficult personalities. If you have a full-blown narcissist on the other side who's out to destroy you, that's a very different situation. But if you have someone who is just an astute and keen negotiator, because that's been their job for 30 years, knowing that their final outcome is that you're probably going to want them to have the last word. You're probably going to want them to feel they've had a bit of a win to get the win that you want. And that actually gives, I think it sounds a bit counterintuitive, it gives a client the power to know we're going to go into this allowing the husband to have the last word, so he can feel that he's won a bit, but actually my client's won because they've got everything that they need to live the life that they want. So that's the sort of the ultimate revenge, isn't it? A life well lived.
Yeah, absolutely, indeed.
So I think that's all really interesting. It's a good mix of I think the psychology of high net worth stuff is absolutely fascinating. I find the geeky details of LTIPs and wealth sharing fascinating, but that says more about me than anyone else. Ceri, we like to sign off with some top tips, as you know. Have you got some top tips that you could say to, if there's someone listening to this going through or about to go through a high net worth divorce, what are your sort of top tips for them to thrive in the process?
So I absolutely would encourage you to get your team around you. It is going likely to be technically quite tricky and emotionally quite tricky. So a good team around you. Secondly, know how that you are going to position that you have got a team around you. And we talked earlier around the fact that being amicable doesn't mean you being compliant. And that's really, really key. So asking for disclosure, and that actually is one of the trickiest parts of these types of divorces. But getting disclosure is about you having a clear line of sight. It's not about you being unamicable, and kind of keeping that line really tight about the fact that I might not be being compliant, but I am being amicable. I really want to work this out with you. I just need to know what's on the table. Then we can work it out.
Perfect. So that's it for this episode of Stowe Talks. Thanks for listening. And thank you so much, Ceri, for joining us.
Thank you.
You can find out more about the work Ceri does supporting clients at www.willowbrookelfp.co.uk. If you would like more information on our podcast, head over to stowetalks.co.uk, and please rate, like, share and review this podcast where you can.